Welcome to the inaugural episode of the Borrowers Roundtable. We have with us Bob Kracht, a debtors attorney with McCarthy Levitt in Cleveland, Craig Meek of the Meek Companies, a developer and operator based in Jacksonville, Shlomo Chopp, managing partner of CPS based in New York, and Stacy Stack, principal with CPS and based in Dallas. I'm Golda Voyen, and I've been covering real estate and CMBS for various publications for over 10 years. So you've discovered that the mortgage loan on your 3 retail centers have something called CMBS debt. You may have already had experience with parties overseeing the mortgage because unlike previous mortgages that you've taken with, say, local banks, every time anything out of the ordinary occurs, you have to go to special servicing for approvals. Now, things have gotten really bad. Tenants aren't paying like they used to. Arrears are piling up. There's a shortfall in the bank and the mortgage is due. When you try to talk to the lender or the person at Wells Fargo, Midland, KeyBank, no one gets back to you promptly. When they do, it's very difficult to have a straight conversation and to get a coherent response. So you have a limited amount of cash in your personal accounts, but you don't want to spend it all throwing good money after bad if the lender won't work with you. How long do you cover the shortfalls? Do you even plan this out from a timing perspective? How do you get an answer from the special servicers when they won't even pick up your call? If they don't respond, do you just do whatever it takes to save your property? Or do you need a full-time attorney to measure every move? There are a lot of questions. CMBS loans are not personally guaranteed or recourse. So how concerned does a borrower need to be? We call this roundtable Preparing for and Navigating CMBS Special Servicing because we want to address all of those questions. With that, I'd like to hand things over to Shlomo.
Thank you. The borrower looks down the pike, sees he's got issues with collecting rent. A borrower sees that it's not something that'll solve itself. It's not just a COVID thing, but maybe a festering issue is there for a while, or it's a COVID thing and we don't know how long it's going to last. He calls his lender, doesn't really get much guidance. From a borrower's perspective, what's next? What have you seen borrowers do? What have you told borrowers to do? And what's been some of the challenges that you've run into?
In most cases, whether it's COVID or any other cause that creates this distressed asset, the first thing we try to do is state enough information in order to push as hard as we can to get it into special servicer and away from the current servicing master servicer. Master servicer obviously has limitations. They are harder to get hold of. They only have their script that we work on. So the first thing we try to do is get it over as best we can, whether we are able to do that ourselves or we work not through an attorney. As you know, Shlomo, we would work through someone like you to assist in that process. But nothing's going to get done until we get to special servicer and get their involvement. At that point in time, you've got some commonality, the fact that they don't want to take the property back in theory. They'd like to do a workout, but it's got to be creative on both sides. You have to have participation from all parts. But without the special services involvement, you're just not going to get anything done. But we have not had a problem getting it into special servicer, provided we present it in a manner or a light that is very telling. You know, it's either we're in a default mode, but regardless of what happens, it's we can claim imminent default, whatever it may be. But once you get that consent to move over and you qualify, then the communication can start.
You've always been current on all your loans. You, as in the borrower, has always been current on all the loans. Never had a default. Isn't the first inclination to just keep on feeding the property?
Not necessarily. Not when you know that you're going to end up with a much bigger problem. So you can feed it short term and satisfy the appetite for a day, but you're not going to fix the problem itself. The larger, elephant that's in the middle of the room. It's just not going to go away. So yes, we'll tell the borrowers you need to do the following things, but you also have to be prepared to meet the special servicer in some manner that will allow them to say, yeah, these guys definitely are real. They want to stay in. And we're not going to make it easy on them, and we're probably inflict what pain we can. But at the same time, there is an aligned, there's an alliance that ultimately can be formed, and that's what's important to get in there. But the short-term fix you're going to do anyway. It's the longer-term items that you're going to 6 months, 8 months, 4 months, that you will be in a default scenario that you will not be able to dig out of on your own.
Mm-hmm. I guess to a certain extent, if you're going to solve your problem, you're going to have to throw money at it. Mm-hmm. And if you have a loan that's at this level and the value that's at, let's say, this level, let's say in the best case, you got to throw money in and bring your capital stack up, your loan's going to be underwater, essentially, or you're going to be underwater. So I guess you sort of have to find a way to tell the special servicer, here's the challenge. Stacy, if you want to jump in and talk a little bit about the borrower's interaction with the master servicer and special servicer, specifically with regards to what the master and special are looking for, what they need as this first step, I think that might be helpful.
I think it's very important to highlight the fact that, Craig talked about getting to the special servicer. Well, there is that gatekeeper, and that is the master servicer. And some of the themes that you're speaking to here about knowing your plan, knowing what the language is in regards to the default scenario is so important. And that's why when we sit here and talk about a plan, and whether it's engaging someone, like us, or doing it yourself, you need to sit down and look at your issue, determine, is it short-term? Is it long-term? How much money do you have liquid to be able to solve it? Would the money even solve the issue? And what is your ask going to be? Because a master servicer does have a script. And the first thing they're going to do is say, make your payment, keep it current. That gives you the most flexibility, but you just have to understand the, fiduciary motivation of each party. And the master servicer, they're your cashier. They're taking your payments. They're typically not the guys that are going to be needing to think outside the traditional box, which is what you allude to with this transfer to special servicing. They're going to highlight the fact that a transfer is going to cost you money. And you're right, they're going to reinforce it's not going to be easy. And so when we talk about just the baseline of what a borrower needs to know at that level of the gate, that's where, again, know your liquidity, know your short-term and your long-term plan, and have a plan A and B.
Part of the issue today specifically is the transferring to special servicing, the costs involved with it. It used to be you transfer to special servicing and it is what it is. Now, if you transfer to special servicing, you're going to be paying out of pocket more than likely. There's certain recourse obligations put in place that you need to worry about. How does a borrower transfer to special servicing? It's like, hey, buddy, I got a problem. Transfer. And once you're in special servicing, are they that easier to deal with? I mean, what are the options on the table?
Mm-hmm. Well, speaking to that, there's very specific transfer language in the pooling and servicing agreement. And what the borrower needs to understand is they are not a party to that pooling and servicing agreement. So as Craig alluded to, there is this thing called imminent default, which basically a master servicer is going to work with the special servicer to determine if there is a very near term default. The other things that will immediately get you over there would be a 60-day payment default. You haven't made 2 months of payment, or you've said, I'm not going to make my payment. Otherwise, unless you've hit those hard thresholds for transfer, it's going to be a dialogue between the master and the special servicer as to whether or not you get to have FaceTime, verbal time with the special servicer.
I'm curious. I feel like emotionally, a lot of times a borrower might first want to get forbearances, and maybe that causes the loan to transfer to special. I think that's often the case. Should a borrower have a more developed plan, as Shlomo alluded to, before requesting forbearances because of cost involved, or also because maybe the servicer will only want to grant so many months of forbearance? I ask because I think of the billions in loans in special right now, many of them got 6-month forbearances when the pandemic kind of started, and those are starting to be over. And it's not so clear how welcome additional forbearances are going to be.
If I may, I think you do need to have a plan, because if you're going to try to get it into special servicing where you can negotiate something, you need to know what the end game is and then what you can work with. So and I think the way I have approached it with my clients during COVID is we were proactive and tried to get to the special servicer as quickly as possible. And we also took the position that COVID-19 was, we treated it as a situation that was an impossibility of performance defense and not a default under the loan. And so we would not agree on any of the clients that I represented. We would not agree to any admission of default. If a lender served a notice of default, we would demand as a part of an ultimate deal, a deferral agreement, not a forbearance agreement.
Can you explain a little how that protects the borrower?
Well, deferral is important in when you contrast that to forbearance. So forbearance, the lender is going to have the borrower admit the default or defaults. They're going to agree that the lender's going to make a statement that they're going to agree to forbear in light of the default from exercising the remedies as long as the borrower does A, B, and C during whatever the term the forbearance period is. There's a number of problems associated with that because in most cases on these commercial mortgage loans, you have a guarantor or guarantors. If there's an admission of a default in writing to that lender, you have an obligation under your other loan documents and other deals to notify those lenders that you're in default on another loan. Okay, so and that can have what I call a top-down default coming in through the guarantor on other loans that otherwise may be performing loans. Okay, so it can cause a potential domino effect. So that's one of the reasons that's why we don't.
And Bob,
yes.
And Bob, on that point, that where they would be admitting that would be in the what we call the P&A, the pre-negotiation agreement, which many special servicers will not allow you to talk with them until they sign that. Is that correct?
That's the first part because they say they're going to send you a hello letter, welcoming you to special servicing, and then the P&A, and the P&A is I push back, and I'd say we'd rather just fight the battle now and on a default basis if you're going to claim one, and I try to negotiate any admission of default out of the P&A, and it's because my position is on a P&A. It's to protect the discussions between the parties so that neither party can say that what we talked about before a loan modification was agreed to or a deferral agreement, whatever you want to call it, that whatever we talk about, neither party can use that as a weapon against the other to claim that they have a deal before you really have a deal. So it's hand in hand with a rule of evidence that deals with using settlement discussions to prove that one party or the other is liable for something. Okay, so the P&A is an extension of that. All the loan documents already have those clauses built into them anyways, but the servicers and the lenders, because some people get sued over these things, want to do the P&A. I'm okay with the P&A as long as it doesn't require any type of admission of default or anything else like that because of those other reasons. Forbearance is, again, it's and usually what you'll get back from the lender after you've done the P&A is an agreement in which one of the first clauses in there is going to be borrower admits their default. Lender's been asked to forbear in the exercise of its remedies, and that they've agreed not to for some period of time during the forbearance period, as long as the borrower does A, B, and C. But what usually those are doing is it's basically in most cases, especially with COVID, a 30, 60, 90-day forbearance was not and would not be sufficient. And I wouldn't recommend that any of my clients ever, do something that short. It has to be, I've been pushing for at least 12 months of a deferral, okay, and with no admission of any type of a default. So the deferral now, to contrast that with the forbearances, it's an agreement between the parties where the lender will allow the borrower to defer payments. And then the object there is that whatever that deferral period is, whatever works for the borrower under the circumstances and what they envision based on their planning, that they're going to need some forgiveness, not that's the wrong word, some deferral of cash so that they have the ability to continue to operate the property in light of the fact that their tenants are adversely affected in probably every state by the impact of governmental orders because of COVID. So I think being proactive and getting to the special server as soon as you can. What you found in COVID is that the special servicers, the master servicers, were overwhelmed. I believe I don't work directly with them. I usually work indirectly with them, and they were overwhelmed and not being responsive to borrowers' requests for either forbearance or deferral or however they presented it. So what we did is with my clients, we started sending letters that were noting that there were governmental orders ordering the shutdown of the various tenants, which basically effectively cut off all the cash flow from the property. And we asked for the lender to consider deferrals. Okay. And if they didn't respond to that, we sent a second one. If they ignored it, then we were prepared to file suit to seek an injunction against the enforcement of any remedies. And, we were actually had to do that on at least one of the many that I worked on since February. But in most cases, the letter campaign at least got it into over to the special servicer. You got to be cautious as a borrower, though, and more particularly the guarantor. When some of your loan documents, because of the fact that they're non-recourse, but they have bad boy carve-outs, and they also have provisions that deal with single-purpose entity obligations of the borrower. If you make an admission in writing that you're unable to pay your debts as they become due, in particular the mortgage debt you're contacting your lender about, that could be either a limited recourse trigger that causes you to be on the hook personally as a guarantor to the lender for losses sustained by making that admission, or for full recourse. Okay, now it doesn't seem to make sense that you're going to your own lender and asking for relief. And that leads to the next point, is that you at the first sign of some problem, whether it was COVID, whether it was a major tenant not giving timely notice to renew its lease, or you see some actual default on the horizon that's going to cause you a problem, you should be proactive. But you should also hire like a Shlomo and Stacy's firm so they can get to the special servicers quickly than most lawyers can. And then the borrower should also be in contact with competent counsel that's familiar with CMBS debt.
So here's what happens to a borrower in our experience, okay? When they sign the loan documents, there are notice addresses. If the lender wants to give you a notice, they have to email or send a letter. They send an overnight letter to X attorney. Your attorney that negotiated these documents to begin with may or may not have been a CMBS expert and probably doesn't know the implications of certain things. For example, when there are lockboxes in place, when the money comes in, how it's distributed. But here's the thing. Contact that the lender is going to reach out with a notice of default is going to be a attorney that negotiated your document, not a litigator. Ask your attorney, he says, well, I know a good litigator. So they hire, you never win real estate foreclosure cases. At best, you could stall and negotiate a deal, because at the end of the day, you took the money, you didn't pay the money. Unless there's some type of default on the lender's side, which you need the expertise to figure it out. So it's so important. And, Craig, you've told some of yourself, you have an attorney that you work with as well. It's so important to have an attorney that not only understands litigation and the law, but understands the CMBS trust under it to be able to know what the implications of every move is and how to find that small letter or a small word somewhere that could trip you up and literally take a $50 million non-recourse loan and turn it recourse in a second.
Well, and that seems to be what terrifies borrowers, is the idea of triggering full recourse. Can you point to things in loan docs that are sort of a red flag that it might be easier to trigger recourse than you thought, especially in those sort of boilerplate loan docs that someone just stamped and moved it on?
We actually had a client come to us recently who hired a massive law firm who complicated documents, and essentially it said that if we file foreclosure and you respond to the complaint, you trigger full recourse. And I looked at it and I said, I checked the closing statement to see how much they paid the attorneys on this one to close. Bob, why don't you talk to that? Like, what are a few key items that a borrower could do to open his loan documents and check? Like, where does he look? What does he look for to sort of avoid, or to know at least what the pitfalls are, whether he could avoid it or not, or hire counsel to be able to do it?
Well, there's number one, just as before I get into the detail on that, is that negotiating the loan at the outset to negotiate and provide flexibility regarding the bad boy carve-outs and the SPE provisions is where you really need to focus from that exposure. And so the term sheet is where you do it. And then you got to negotiate that at the term sheet level, because if you don't, you're going to get a 60-page loan agreement back from, Lenders New York Council. That's going to be just, they're basically their standard fare, which is extremely complex, convoluted provisions that I call that, it's basically a commercial minefield. No matter which way you step down the road, you're going to step on one.
The originator will give you whatever you want to make the deal. So sometimes, and you're so excited to get, you just signed the term sheet, but the attorney just gets the term sheet. It's out of the originator's sales guy's hand, and he just follows to the letter of the law. And at that point, you got to reopen and go to their pre-committee all over again. You got to get it up front.
It's extremely difficult to do that, because if you've allowed it to go to the term sheet level and you didn't take care of those issues up front, granted, you can't get everything you want because the lender controls the cash, but you're going to have a hard time getting them to back off on something like that, because you got a new lawyer involved that's actually looking at the stuff and reading it and understands how it works. So, but to get back to the other point is, you have to, there's a section in every one of these commercial CMBS loans, non-recourse loans, that deals with, it's usually called an exculpatory clause in the loan agreement. And then that typically mirrors what's in the guarantor's recourse obligations, okay, the guarantee. And there's two components to it. One is one section, the first section is called, refer to it as limited recourse for actual provable losses caused to the lender by reason of borrower misconduct, okay? Those are, bad boy recourse carve-outs. Then there's a second component right after that, that's what is known as full recourse provisions. And so what you do is, if you want to see what you can do and can't do, go down and read those, review them with a lawyer, and determine, have you already done something, okay, that may have triggered either limited and, God forbid, full recourse. Mm-hmm. And that, by the way, knowing that up front before you start negotiating or even pushing back against your lender is important, because you may not want to poke the bear, so to speak. Because of COVID, the major thing that I've seen with my clients is they've got so many tenants coming to them looking for relief, deferrals, okay? And you've got to understand your loan documents. Are you permitted as the borrower to modify and give that type of relief to your tenants without triggering some type of either limited or full recourse against the guarantor? Because certain types of leases, major leases in particular, always need to have lender prior written consent of the lender. Okay, better to get counsel and people who are competent in negotiating deals with special servicers like Shlomo and Stacy involved quickly up front, so you can have a two-prong approach. They'll deal with and negotiate the deal with the special servicer, the law firm in the background reviewing and detailing and looking at what the risk and exposure is and what you have to do to comply with the loan documents during that circumstance.
Doesn't this speak back to what Craig has experienced with some consents being accepted by the special servicer when the borrower was just trying to do what they needed to do, which their knowledge base is how to operate a property? And, they're seeing tenants that are not paying, and, they need to take care of things, or there's maybe a TI situation that needs to happen. I believe that Craig has had direct experience with some of that.
Well, you mentioned poking the bear. I'm curious, Stacy, everybody, what constitutes poking the bear? I've heard that asking for a 12-month forbearance was considered, a little aggressive at the outset. And now it starts to sound like maybe that made more sense. But none of us knew how long this pandemic would go on, obviously. What do borrowers need to do to, show they're on good behavior, kind of? And any instances of them kind of stepping in it with the servicer that anyone can point to?
With the lender, I think what we all need to remember is we're all humans on both sides of this. We're borrowers that are humans trying to operate our property, and on the lender side, that asset manager is a human as well. But taking the human factor and adding it in, we all didn't know what was happening. And again, I go back to, there is a script on the lender side. There is a package of information that they're looking for, and there are constraints based upon the fiduciary motivation of the parties at play. So a master servicer can't grant, they don't have the ability to grant this forbearance typically, not a short-term nor a long-term. The special has to have certain approvals come from the bondholders, the controlling bondholder, once it goes beyond a certain point. So reaching out immediately, even though you may know you need a 12-month deferral or a 12-month forbearance, is not something that they can grasp necessarily. And to magnify that, you need to be cautious, because if you ask for that day one, their heart is going to go immediately to the fact that you've got a super serious, dire situation here, in which case, depending on what your scenario is, you may not want to present the case that way initially if you do think it's short term. So I'll kick it over to you, Shlomo, or you, Craig, with regards to what you've seen and been able to, but there are constraints on all sides, and that's what this whole roundtable is about.
Let's talk. This is extremely important to know about forbearances. This whole concept of giving a forbearance without a full transfer to special servicing, which is how these things are done, is a workaround. The special servicers and the trusts are giving forbearances and deferrals to the letter of the law. If we weren't in the middle of a pandemic, it's my opinion that would never happen. Because the only way to modify a loan, to truly modify a loan, would be to transfer it to special servicing, at which point they pull an appraisal, at which point they go through the whole process, and a year later, you either have it foreclosed on you or you worked out a deal. The thing with COVID is that everything went bad at the same time. And if they would go through the entire process, the entire system will collapse. So the attorneys got together and they figured out a way how to sort of not transfer to special servicing and cause the system to have issues, but instead use what's called a consent, similar to, hey, master servicer, I have a lease. The master servicer says, okay, hold on. Hey, special servicer, we have a lease. Do you approve it? Do you not approve it? It's essentially a consent. We're asking permission to do something that is, reasonable within the context of operations. So when you go and ask for forbearance, which means I'm agreeing I'm in default, but you, lender, agree not to pursue me in foreclosure for X amount of time, and deferral that post this time that you won't pursue me, you'll give me a time period during which I could pay back the rest of the loan, or the payments that I didn't make yet. When you go to the lender and ask for that, to begin with, their dander is out, because there is the slight hint that a forbearance is not enough, provided your property will not take down the trust by being transferred to special servicing and getting an appraisal on the spot. They will not agree to a forbearance deferral. They will transfer to special servicing and go through the entire process, because just to put a Band-Aid on it doesn't work. You need to make an argument as to why the property could recover, as opposed to when you go for a modification, you can't make an argument the property will recover on its own. You need to explain as to why the property needs help to recover. With regards to poking the bear, anytime you open up a negotiation, it's now if you negotiate to buy a property, you're two guys, you know each other, or you don't know each other, but you're friendly. I want to buy it for X dollars. I don't want to sell it for X dollars. You come to the deal, you don't come to the deal, you move on. But the reality is, when you go into negotiation with the lender, you're saying, hey, guy, you gave me money when I closed the loan. Thank you so much. Now I want to talk to you about how you shouldn't get what you bargained for. That's poking the bear, right? Now, if you're exposed, if you have a weakness, you need to know that before you go in, because the lender will use every leverage point, and they should, to have the negotiation work out in their favor. So that's why you need to sort of get out ahead of it and know what your weaknesses are before you head into negotiation.
The better question then is, if you know that you may need a modification and a forbearance would be a Band-Aid on a flesh wound, what pitfalls should you be most careful to avoid? And then I'd also like to talk about deed in lieu of foreclosure, which seems like the next step if modifications can't work. And there's a general mythology, it seems like, in real estate that people just, they say, hand the keys back, which sounds like this very placid process, but of course is much more complicated. And lenders may not be remotely amenable to deed in lieu transactions. I don't think we've seen any yet this cycle, but I could be wrong about that. Thinking more in terms of how you approach the servicer when you know you need or want a modification. How can you position the property situation, your own situation as the operator, such that they will be amenable?
Need a plan. Here's the deal. When you take a loan, the first, let's say 70% is the lender's piece. The next 30% is your piece. If the value goes down, you're out of the money. Okay, what are you going to do for me? That's what the lender wants to know. You need to have money. You need to show them, we will either make this investment, we could operate better, or you'll take it over and good luck operating it, and you'll make the investment and you'll have to take the risk on operating. Stacy, from your perspective, coming from the lender side, sitting around the water cooler, right? Or standing around the water cooler and talking about this borrower this borrower that. We know there's no HIPAA regulations and when it comes to CMBS special servicing. Can you talk a little bit on that front, please?
I think that when we see someone call immediately, and this is very important, we're going to look for the borrower that knows their property. And what do I mean? And how do you indicate that? Well, you immediately need to have ready your financials, and you may have already, you may have a quarterly reporting requirement, but you need to have your financials ready. You need to have your rent roll ready. You need to have the updated statuses of your receivables ready, your payables ready. You need to also know, what does that do to your near-term cash flow? You need to understand, are you sending your payments in, or is the bank sweeping them from an account? You need to know what your level of reserves are with regards to your replacement reserves. That's just your standard. If you're doing your standard annual items, you need to know if there's certain levels of reserves associated with tenant improvements or leasing commissions, because that's going to be the facilitator to how you may need to, if it's an occupancy issue, how you may need have money in reserves and ready to take care of that property and stabilize that property. And so these are all very granular levels of details, but what that signals to that person on the other side of the phone is that you know where you stand today and what you need to get to tomorrow. But and that's kind of what we talk about on the lender side historically is, that guy's a good operator, and not just because the property's done what it is historically, but because if I get a borrower on the other side of the phone that says I need help, that's, I might want to do something to help them, but if I can't get that information, then I don't even know how to get you to how to guide you. And it's not my job to guide you as a lender to that. But, I can't do anything because my eyes are blind. And so I have to go to a worst case scenario. Okay, great. Borrower just told me that there's major issues with occupancy. Tenants aren't paying. Tenants are leaving. The pandemic has happened. I have to go to the worst case because I have to protect my position as a lender. I have to protect the trust. I have to grab cash immediately and control that cash, because now I also have a confidence issue with regards to what you're able to do and what you know about your property.
One thing that I've heard from borrowers is saying, why would the lender want this property? Or the flip side, the lender's got all the cash coming in. What's my leverage? It goes back to what you're saying about protecting the trust. It's not just about protecting the trust. It's about maximizing recovery. Taking money from the sources that special servicers have to take money from to invest into properties is an equity game. It's not a bond game. It's not a debt game. They're not in that game only to the extent it assures them, or they believe that it will result in a greater recovery to the trust. But if you have money that needs to be pumped into the property, that is leverage that you didn't otherwise have, that you now have.
We're seeing some huge deals, hundreds of millions of dollars in SASBs where the reserves are paying the debt service for now, or at least I've been told this. That seems like a wonderful option if you can negotiate it. Craig, as a borrower, have you had any success in terms of negotiating reserves or other cash on the sidelines being put towards principal or interest, or both?
Yes. We, to clarify a couple things, Shlomo's aware of this. Our position's unique in that we are, we provide, in this cases, the property management for the day-to-day operations. But my role is then the step above that is asset management. And the reality is, in almost every deal that we've had, the CMBS loans, I'm the one that has the most direct contact on a regular basis with the lender, in this case, the master servicer. So from our end, early on, as everything's being set up, we form a comfortable relationship saying, you're going to be my contact, and here's what it is, here's what we're doing. And we keep them informed. So this isn't something that when we run into an issue, run into a problem, obviously every loan we have, there's some trigger square footage that you have to get their approval from. And then, of course, you get that. In some cases, it still requires a special servicer to get the bondholders to agree as well. But one of the things that, so from our end, there's no surprises with things that we see 6 months or anticipate 8 months down the road. We will make sure that the master servicer understands fully that here it is. I do have authority to speak on behalf of the borrowers, and they know that I know more about the asset than the borrowers ever will. So we know every aspect of it. So we're reporting regularly. We give them more information to help them, not anything that would go against us, but that they see that the property is being properly managed in every aspect. We have been successful in some situations to not the replacement reserve as much as the rollover reserves or some other special reserves that they would put in at the time. I can tell you of the 6 that we've been involved with, we were not involved with the preparation of documentation for the loan. And I can tell you in every case that the legal group that put it together did not have the experience for the CMBS loans at all. And so they're not ones that you could even go to. But in doing that with the special service, the master, we're able to get them to acknowledge that there's a bigger pending problem coming down the road. I know we're all talking about the COVID, and that's obviously the next year is going to be very telling because commercial real estate is going to be tremendously affected, tremendously, and it's going to, deal with a lot of different things. Some of the properties we've been involved with were ones that, I've got several, Shlomo knows this, that probably purchased a property in 2007 at the day and hour, the height of the market, and probably overpaid $10 to $15 million for the asset because it looked good on paper. And so we always know that in many cases, we're watching the fair market value, what that true appraised value would be, because that's very important once you get to getting to the special servicer. We look at those things way in advance. So we've been successful in 3 situations getting to the special by virtue of claiming the pending imminent default. And so when you have the assets, it's got $52 million of debt on it, and yet the property is probably worth $35 million. We don't start with that, but we do start with the fact that one of our huge tenants that takes 35% of the project, that their loan is coming up and, their lease is coming up, and we're getting indications that they may not renew. And so we're way ahead of that game. So we want to get the special servicer, and we have not had a problem given our relationship with the master in their knowledge of us, how we report, how timely we are with all of that. So we always end up treated in a very positive fashion. There's no games. It's just, here's the facts, here's what we're dealing with. Yeah. Once we get the special servicer to say, yeah, this we see as a pending problem that could create a huge default on the property, that's where we want to get involved very soon. And so whether I'm able to do that myself or we bring in the third party, say, here's what I got, we need your expertise, to bring it in. And we also want to know who that special servicer is. We usually know, but you never know who you're going to get as the person assigned. And so there are those that are easier to deal with than others.
Be nice.
We have been successful.
No, be explicit. Who's the worst to deal with? Please.
But the reality is that to the extent, even once it gets to the special and you get through that veil of secrecy that they always like to hide behind, and they realize all of a sudden that this guy's really looking after the asset for the borrowers and is really wanting this thing to work out. I have, with the exception of one asset, I actually, after dealing with the special service for a couple of months, it's like, listen, I'm going to be in Miami on business. You mind if I stop by your office? I'd like to put a face together and just talk. And I've never been denied that. I've gotten in front of every time with some interesting people. And then once you do that, you're able to find out some commonalities, with projects that I've seen. I was reading recently in the paper that you guys, were in charge of this, large mall that had gone dark. And I said, did either one of you guys work on it? And one of the guys patted the other one. He said, that was his baby. And I said, well, you took like a 60% hit. He goes, Craig, don't even start. He said it was, we thought we had it worked out. And when we got the notice from Belks and JCPenney's they're pulling out, we just gave it away. And so, with my personality, it's like, well, that's not something you want to put on your resume. But again, it is the persistence of information. And then we become kind of a confidant, but they recognize that they're going to be dealing with the third party folks we bring in to say, listen, I'm just a stupid redneck from Jacksonville, Florida, and I know enough to be dangerous, but the reality is, I'm very savvy on debt structure and what goes on, but I also bring in as soon as possible the third party consultant, because that's the piece that they really get down to the nitty gritty and can make that work. My portion then is the liaison with what's being thought of as maybe some workout structures. And then I have to convince the borrowers as to why they have to be willing and ready to commit $4 million for some deferred maintenance and things like that, because it has to be done one way or the other. So we're working it simultaneously with all the parties.
So here's an interesting thing, Craig, and I know this knowing you and having worked on some stuff with you, is that one of the things that I'm most proud of in my work with borrowers is not the times that I get a guy 60% off on the property, or it's the fact that often I'm able to keep a property out of receivership, not with legal way, but just the fact when you have transparency, the lender says, why do I have to hire a receiver? I'm getting factual information on an ongoing basis and all that. And I know for you kept the property technically out of receivership probably for a couple of years.
Yep. Several properties, but it was just that. It was the fact that once we were checked out by the special servicer, they found commonality of other properties, et cetera. They recognized our role, which is unique. So we're not the normal, property manager. We're not the foreign investors who are absentee owners who really don't know anything about it. We deal from a different scenario, and the special servicers typically, after working with them for a while, say, hey, Craig, do you do any hospitality? Sure. What do you have? But it's stuff in our region that they're looking to say, we don't want, in theory, we don't want to put a receiver in place. In the assets that we manage, they recognize that we're better than a receiver if they put in a third party, because we are that close to the asset, that it's total transparency up to the point of the things that I don't share with them.
Yeah.
They don't ask the questions. I'm not going to tell them, but the reality is in almost every case, you know what you're dealing with the asset. The owners know that they're COVID, that you're going to have a great deal of default. Then it's a matter of how do you deal with that particular scenario of default. And with the COVID, it's one thing to give a deferral on rent or work it and add it back to the backside, but the project or the challenge is bigger than that because some of these retailers just can't survive. So it's not a matter of, giving them X amount of free rent. They still, these mom and pops that comprise a lot of the smaller tenants, they're finding it's just not working. They don't have the capital reserves, or they're finding out that, we had 50,000 feet and we've been working remotely now for 3 months and we're more profitable than we were before. And we only need 10,000 square feet. So we're leaving and we're moving to another building and, we'll sublease or give up the space. So you've got a number of different scenarios under the COVID situation that is very unique to just.
Yeah, and I'll add something to what you're saying before about the receivership. Borrowers have to recognize this very important fact. When a lender comes to you to ask what's going on, if you don't show that you're as experienced as they always thought you were, or as knowledgeable, or as forthcoming, you have an issue. To the extent, and these are two companies that happened over 6 years ago, I'll just say it. One with General Growth Properties and one with CBL. I've had conversations with both of them, and they asked me as follows. How can we force the lender to take the property? Meaning the property is not doing well. We're not feeding it, but we have our resources in place, leasing people, we're managing it. It's just consuming our time. The lender doesn't want to foreclose, doesn't want to put in a receiver, and we're required under the loan documents to operate it. And the reason this is happening is because the lender recognizes that these guys are the best guys to operate the property, and they're not fooling themselves to think they should just put in a receiver. On the flip side, I get borrowers calling me, "Oh my God, what do I do? There's a receiver going in." I wish you would have called me 6 months ago when you started having a problem, and I could prescribe to you exactly how you need to deal so that the lender should trust you to be the guy. We have borrowers that don't even recognize how experienced they are in the asset class and specific property that they have. And when you show it to them, they're like, "Yeah, that's interesting. But how do I get the guy to see it? How do I talk to him?" And that goes back to the original point.
Stacy, do you have any thoughts, tricks, tips from the lender perspective, how to get the servicer to see your point of view?
I mean, it all just comes back to data and understanding the market and presenting it confidently. How many times have you heard someone say or say something and they say it with the right amount of confidence, and you could totally change the inflection of the same sentence with the statement of doubt, and it changes perception. So it's all about the perception, especially as the market continues to, I heard a Trepp podcast yesterday with regards to the way that delinquency is slightly falling, or those forbearances are deflating delinquency. I think what it comes back to is you just have to know how to present the data, present it confidently, and make it relevant to the parties with which you're speaking. So to remember that, again, that master servicer, he has to prep that case for special if that's where it's going to end up needing to be. And so for you to, whether you're trying to do something as a performing arrangement or trying to do something over with a special servicer, they still have a baseline of information that you need to gather and present in a concise, confident manner. And that's what CASE is here to do. That's why you engage asset managers. And that's why you have a good attorney typically involved, albeit not a litigator, on the front side.
Yes. What do you mean when you actually get the loan documents written up?
No, I just mean at the start, meaning that you don't want to throw in an attorney letter before your initial call or even with your initial call. It scares the servicer. It's like when you go to jail and you lawyer up. Everybody's going to shut down.
Yeah, and quite frankly, if you lawyer up and you're innocent and you're good, it's okay, but you own the property, right? So that's an issue. Bob, I'll just say this with regards to lawyers. We had a situation now where a guy was less than 30 days late, and he essentially is current on his loan. And the asset manager that's involved with this is new to the job and has got a lot on his plate. And he made an offer to the borrower. And the borrower thought that the way to respond to an offer is to get his attorney to respond. So he got his attorney to respond with a letter. Well, when you bring one attorney in, attorneys talk to attorneys, right? That's the first rule in business. So you bring the other attorney in. What do attorneys do? He sent them a default and acceleration letter when the guy was less than 30 days late. He accelerated the entire loan. Now, obviously, that's something that gets resolved with time and patience. But the point is, that was a huge mistake. And not only that, but the guy that wrote the letter didn't have any perspective with regards, meaning the borrower's attorney didn't really understand, what the implications are over here or what the CMBS side of things. So I just an important point. When you see a light coming down the tracks and it's another train, okay, you see it's coming, it's hitting you. Before you even talk to your lender, you need to have a CMBS experienced attorney / litigator, because if you get a really good CMBS attorney, he'll tell you to go to a good CMBS litigator, to review the documents as soon as possible, have a meeting with your property management guys to understand how you've been operating the property, and sort of have that attorney ask these questions to you and your team. Say, hey, have you done anything similar to this? How have you dealt with this? I see the rent roll. And this attorney needs to go through your rent roll and financials too, to a certain extent. But he won't. But he needs to, which is how we come into the picture as well. We actually will pull apart your business and put it back together and come up with a conclusion as to where your weaknesses are, where you need to protect yourself, so that when you bring on the attorney, or if you have that attorney on already and some of those attorneys call us to come on board, we're able to quantify the risks involved and know whether to, as we said, poke the bear or just walk away. So I think the most important thing for borrower is to be able to know his status and know his weaknesses, and then take it from there. That would be like the most important thing that I would put out there. And you do it even before you talk to your master servicer, unless you have the skill set that Craig does and understands, where these pitfalls are.
Two things regarding that aspect. I always counsel my clients when I get involved, and usually I'd rather get involved much sooner rather than later, because I can help them, develop the game plan and also look at the risks and everything else by going over their loan documents and determining, to what extent we want to poke the bear again. And but I also counsel them that some of these the special servicers, as soon as they see a lawyer show up at the table for the borrower, they too will get counsel. And I've seen it actually happen in the past where they've been negotiating with the borrower. The borrower retains counsel. Counsel writes a letter, not even a threatening letter. And next thing you know, it's been referred to litigation counsel in the state where the property is located. Foreclosures filed. They're seeking an appointment of receiver. And that's even happened in cases where the loan was not in default yet, but they let it. They wouldn't even talk to the borrower until it went 60 days out, and then they filed foreclosure and put a receiver or tried to get a receiver in place. But so you have to be cautious on when the lawyer steps into the picture and things like that. And there may be circumstances where you're forced on it because they're going after you right out of the box.
So it sounds like timing and getting out in front of the problem and not sending your attorney in guns a-blazing are the lessons. But I think you've all hit on the fact that the fact is a lot of people take CMBS loans without reading the loan documents carefully, and they're complex and being interpreted in real time these days. Last time there was a massive crunch with CMBS debt being transferred to special and, foreclosures and eventually lots of liquidations. There were revisions made to how CMBS works, and some people think that risk retention and getting rid of the fair market value option, that those have improved how things work. Obviously, no one anticipated a pandemic, but now that we're here, it looks like we're going to learn what was flawed about CMBS 2.0. So to conclude, I was wondering if everyone would want to offer their 2 bullet points for what their lessons are from the pandemic so far and how CMBS should work and will work in the future?
I'll go first on it. First of all, just my perspective on it is that don't admit default even if you are in a typical traditional payment default. There is an argument that can be made in many states that because of the pandemic, because of the governmental orders that are causing tenants to close their operations and ordering that people stay at home, which are the customers of your tenants, that's something that has rendered your ability to perform under your loan documents impossible. Okay, so there's the doctrine of impossibility of performance. When you look into your loan agreement, every loan agreement that I've seen, and I've been looking at these things for 30 years, they have provisions where there's borrowers' representations and warranties that they will comply with all legal requirements, a defined term, and that includes governmental orders, et cetera. Okay, rules, regulations, laws, statutes, governmental orders. And in many cases, when it's a retail shopping center of that sort, the landlord and the borrower are also required to ensure that their tenants comply with all legal requirements. So you've got the contractual obligation to make your loan payments. All of your tenants, or the majority of your tenants, non-essential businesses, were basically shut down, and some are still there. Some went out of business, but yet you're required to make your loan payments when the income stream from the entire property is closed off. What can you do about it? If you admit default, you don't try to at least leverage and push back somewhat, you're probably going to lose your property. But if you take the position that it's that the doctrine of impossibility of performance applies, then you may have a basis to leverage the lender and get a deferral as opposed to forbearance and ultimately foreclosure.
Stacy, how about you?
I have seen so many borrowers that are savvy at what they do, but just don't understand the constraints of CMBS. So I think for me, it would just be to find, even if you're an expert on your property, find your team of experts within the CMBS constraint that speak the language so they can bridge the gap and get ahead of it early. No matter who it is, there are many of us in the industry, and there are different features, like the attorney, like the asset management, like the borrower advocate. You need that. You need that to make the market efficient. And that is what I like to believe our market is positioned to do, to be efficient, to work together, because this is a great source of funds. It's it's something we want to have continue, in my opinion.
And it can be improved,
Always.
What do you think, Craig?
I think that the one of the bigger issues you have with working out these loans is you have to have a buy-in, an understanding with the borrower themselves. So we can present that in different manners, but they have to understand exactly the levity of the situation, what their true exposure is, what their potential exposure is. So when you look at something and say, guys, I'm working with, let's say in this case, Case, and we've made some progress, but you're going to need to come with $4 million, and as part of this workout, and it's an interesting structure. Here it is. Well, Craig, we don't want to put any more money in it. And I said, well, then we'll just go ahead and let them foreclose. I said, well, you guys need to talk to your tax counsel, because when you get foreclosed upon, then you're going to end up with, in the case of some of these have been massive forgiveness of debt, because the not only the primary principal, but when it goes into the special service, they start sweeping the account. Then you've got all these extra fees that are added onto it. So all of a sudden, that $48 million loan, when it goes to foreclosure, is $56 million. And so we have that component, and the fact that all of their losses they took all throughout that time they held it convert to ordinary income. So I'm presenting to the group to say, look, you come up with $4 million, or you're going to end up with about a $20 million tax liability. Seems to me that it's the path of least resistance, and you could probably keep the asset with the future upside in place. And that's one of the things we always make sure that the borrower understands the importance of what they ultimately will need to do when someone like you gets involved and actually gets something on paper that seems to make sense. I have not, in all the stuff we've been doing, the special servicers do not necessarily want to take that property back. And if they have a good operator who understands it and really knows the market well, and there's things we'll do, and at times it gets a special servicer, and it's just, again, there's some of this is just self-preservation too, but we'll say, listen, we're here to help in every way possible. During the time it's going to be a special servicer, we're going to drop our property management fee or asset management fee by 25% or 30% just to help with the cause. And it just depends on where kind of what they're looking at in those hot buttons. But we're still trying to get the that line of communication is just so important. That's really it from our standpoint.
So get out ahead of it, hire a good team, and have money.
Yes.
Yeah.
Shlomo.
Yes.
What are your takeaways, Shlomo? And if possible, looking forward in terms of how you think the system will change as a result of this challenge.
There's a document that forces the special servicer to act a certain way. It's called the pooling and servicing agreement. It's what tells them what actions they must take on behalf of the bondholders. And the reality is that if you're dealing with a lender, and you're in default, their job is to foreclose on you. That's the remedy they must undertake. They have the option to modify it. Remember that. They have the option to modify it. Let's remember, a modification is harder work than a foreclosure. So that's the first point I would say. With regards to, I'll talk about regards to moving forward, and I'll talk about when you're selecting an advisor, what to look for, because there's many out there and there's a lot of work, and it's important questions you need to ask. But with regards to CMBS, I think what COVID has shown us is that the premise of CMBS is very, very much in danger. Because the premise of CMBS is I'm going to take a mortgage property, a loan, that is a complex instrument to manage because I need to understand the underlying operating property. And I'm going to put in place an agreement that dictates as to what I, as a manager, maybe a master servicer, a special servicer, must do in the event there's an issue. And because I have a set of rules, I'll get some other guy who doesn't know anything about mortgages to buy it. What COVID has shown us is that you can't set rules and account for everything. What 2010 showed us, 2009, 2008 showed us, is you can't set rules and figure everything out up front. You need flexibility. And that flexibility building into CMBS is going to be something that a lot of very smart people, clearly smarter than me, are going to have to figure out moving forward, or else that market's going to have an issue in the future. Very briefly with regards to an advisor, right? You're a borrower. Like I said, you never defaulted on a loan. You have an issue. You know that you don't know what CMBS is. It's what do I do? The lender won't talk to me like my lender, my savings bank does. What do I do? There are many advisors. There are great ones, and there are some that are okay. The first thing is what's cheap is expensive, and what's expensive is cheap. You're working with a multi-million-dollar property, 5, 10, 15, 20, 60, 100. Don't look at just the fee. What do you look for? You have to ask yourself, what is that process? It's not like I'm a mortgage broker and I put together his income, his expense. Everyone wants to do the deal, right? The originator wants to make the loan. The appraiser wants to get it as the value needs to be. The bondholders want to issue bonds to make money. Over here, it's the opposite. No one wants to give you a discount. No one wants to solve your problem. It's a lot of work. You're asking for them to do, essentially to admit that their investment is flawed. You're the guy that took their money with no recourse whatsoever, and you expect them to give you the property. That's not going to work. You need to have a process and a reason as to why they're going to do that. And you need to ask your advisor, how are you going to get these guys to agree to give me a discount? They're in a first lien position. Why don't they just foreclose, own it, sell it to some other guy? They'll do better that way, probably. Who knows what's going to happen, right?
Not now, because they don't even want it sometimes now.
Well, yes, but at the end of the day, who said you're the right guy? You shepherded it right into a bad problem. Now, granted, COVID is COVID, but generally, you need to ask that question. I think that's the first thing. The second thing and final thing is that I'll just recount a little story. And Stacy and I were talking to an asset manager that I did a deal with years ago, and he said, "You're the only guy we've done a deal with," and I said, why? And I said, what is it about advisors? What is it about advisors that the lenders just despise at times, some depending on the person? And he said, it's very simple. When we deal with a borrower who doesn't know CMBS, okay, that's the package we inherited. It is what it is. But don't give me another guy in between who doesn't know how to deal with us to be another level of problems in between. So it's so important to be able to have the confidence of the lender that you know what you're talking about, you're not wasting their time, and quite frankly, doing the majority of the heavy lift that you're asking them to do for them. Let them go and edit it as they want, but do the work for them so that they don't have to do all that work on this whole pile of loans, because, dirty little secret, special services are not paid nearly enough for the amount of work that they need to do, not getting paid enough. So I would say it's key for you to interview your advisor and ask, what are you going to do? If it's just we're going to write up an income and expense, send it to the lender and hope they'll agree to us, walk. Just move on to the next guy.
Well, on that note, thank you so much, everybody, for joining us for our inaugural CMBS Roundtable. I hope you'll join us next time.